Yes. Before my friend starts, there's a slight tweak in the sequence. Mr. Jaideep Gupta and Mr. Bhushan will be going immediately after Mr. Padwani.
So, my lord, I have been given 15 minutes. I will stay within that time. My lord, I have
You
made...
got an hour more. Otherwise, if you would have concluded the other day, you would have got only 2 hours. You are getting 2.5 hours.
Correct, correct. So, my lord, just to facilitate and save time, I have put in writing what I had argued on that day. It is just 5 pages. I have given it to your lordships, my lord. If your lordship will see page 1 of what I have handed over, my lord, the written submission. Page 1, I need not read or repeat. I had already told your lordships that Delhi, the promotees...
Situation is reversed.
Yes, is reverse. I have recapitulated that in page 1, my lord. I need not read it. Your lordship would see it, my lord. That is the position in Delhi. Now, on weightage, the argument of weightage for the promotees, which was made, also I had submitted, my lord, and that is the second point at page 2, that 3 avenues of accelerated promotion have already been now opened for them. And I have at page 2 given as A is the first avenue, that 25% quota of, in district judges by way of LCDE. And at the extract is of your lordships 2025 AIJA judgment, my lord, where your lordships have recognized this, that purpose was behind providing a special quota is to enable meritorious judicial officers to get accelerated promotion. Then at page point B, I have said that this your lordships have also now opened from junior to senior level. This is the second accelerated advantage. And at C, third, your lordships have now also made them eligible to compete for direct recruitment. This is the third. And and therefore, my lord, the submission is that no further weightage perhaps your lordship may consider granting, my lord. And weightage, I have said that D has been disapproved in the 2002 judgment, that para I have quoted. Now, my lord, what I wish to spend some 10 minutes is on my point number 2, roster for maintaining seniority, because in my submission, that may be an acceptable proposition. The doubt which your lordship expressed that because direct recruitment can get late, people join later, and then they can't get those earlier slots. I have tried to make some suggestion, my lord, for your lordship's consideration. Can I just take your lordship through these 4-5 points, this one page, my lord? Now, roster for maintaining seniority. It is submitted that the contention that the roster system introduced pursuant to the 2002 judgment has failed is incorrect, as the roster system has never been given a fair chance to operate due to lack of year-wise recruitment across all streams, which is an essential requirement for its full and effective implementation. The 2002 judgment in paras 2930 laid down the roster as a post-based system designed to secure fairness, transparency, parity between promotees, LDC, and direct recruits. When recruitment is done regularly and on time, the roster system helps all 3 streams to move forward with a proportionate representation in every block of 4 vacancies and also prevents disputes of seniority. So if properly implemented, it is 2-1-1. So in every block of 4, we will have all 3 categories. Now, Malik Mazhar becomes important because your lordships have laid down a yearly schedule. Your lordships have said calculate vacancies, advertise by March, complete the process, by September have the select list ready, and by October 31st, all 3 streams should be appointed. That is the schedule which your lordships have laid down in Malik Mazhar, my lord. Malik Mazhar is also on your lordship's compilation. If your lordship, it is in volume 5A, and page number is 483. If your lordship wants to note, I'm not going to read it. That schedule is there. It was read earlier. Then if your lordship will come to point 3I, the applicant submit that vacancies for each stream, that is promotion, LDC, and direct recruitment, should be calculated with reference to the total sanction strength of the cadre to ensure proportionate representation and continuity. Once appointments from all 3 streams are made for a given recruitment year, seniority must be assigned strictly in accordance with the order of slots under the roster on a yearly basis. The approach implemented on a yearly basis would balance inter-seniority and maintain the 50-25-25 ratio in a block of 4 vacancies. This is judicially accepted, my lord. That judgment I have reproduced at serial number 6 of the same point in that state of Punjab's case, where I have extracted that para, where in fact the court said, because it's a yearly recruitment, operate the roster. Now, my lord, the other 2 points are the doubts. What happens when one process gets delayed? And then comes the heartburning, because that man is coming a year or 2 later and then wants to get that earlier slot. I've tried to say something about it, my lord, for your lordship's consideration. Now, I'll read 4 and 5. Experience across state shows that promotion under the 50% promotee quota are generally made promptly, while LDC and direct recruitment appointees are often delayed due to litigation or administrative delays. In such cases, this court has consistently held appointment should relate back to the year of vacancy. Now, next, if each recruitment process is completed within the recruitment year and all streams join, then there would be no cause for any heartburn by operation of the roster. This court can mandate that process to be completed within the year or at any rate within the next year before that year's select list is finalized to minimize the cause of heartburn. If I can pause here, this is important. If you are completing the process as per Malik Mazhar and by 31st October, all three streams are joining, then they will be fitted into the roster, no problem. My submission is, my lord, perhaps your lordship may consider mandating, because the next year's select list at the earliest will be available only by October of that year. That is the mandate, by September of that year. That is the mandate of Malik Mazhar. If your lordships can provide a safeguard that even if there is delay, it should not go beyond the next year, then also, my lord, there will be no heartburn. However, if there is more delay, my lord, then what is stated subsequently is then to maintain the seniority and maintain parity, they must get the earlier slot. That is what I have submitted, my lord, and there is no escape from that if we are to go by the roster then, because then that is the only way you will be able to give a proportionate representation to everybody. So if I can just read this 5, my lord. In case recruitment process is completed within the recruitment year and all streams join, then there would be no cause for any heartburn by operation of the roster. This court can mandate the process to be completed within the year or at any rate within the next year before that year's select list is finalized to minimize any cause for heartburn. However, if due to certain circumstances, there is a delay in recruitment and the direct recruits of a particular recruitment year are not able to join within the recruitment year during which the vacancies had arisen, then the date of appointment joining should not be a relevant factor for determining seniority of direct recruits. It would suffice if action has been initiated for direct recruit vacancies within the recruitment years in which the vacancies had become available. This is so because delay in administrative action could not deprive an individual of his due seniority. Any such initiation of action for recruitment within the year would be sufficient to assign seniority to the direct recruit in terms of rotation of quota principle so as to arrange them within the promotee's vacancies. If the process of recruitment has been initiated during the year itself, then even if the selected candidates are appointed or join in subsequent year, the selected candidates would be entitled to seniority. Now, this judgment I have quoted, but I must point out immediately here, in this judgment, the fact was that all three streams joined in the same year, 2007. And therefore, what this court says, para 67, the court has, however, taken the view that date of joining is not relevant. Para 67, officers belonging to different streams have to be confident that they will be recruited under their quota and get seniority as per quota and roster. In the event seniority is to be fixed with date of joining of particular stream, it would lead to uncertainty and making seniority dependent on administrative authorities, which is neither in the interest of service nor serves the cause of justice. We thus conclude that roster is fully applicable for determination of seniority. Officers of different streams selected in a particular year, even though they were allowed to join the post on different dates, shall not affect their inter-se seniority, which is to be decided on the basis of roster. So this is what the court has mandated. Otherwise, my lord, I should not finish this point without stating this Punjab and Haryana High Court relies on Parmar's case. Now, Parmar's case in Meghachandra was held to be not good law by 3 honorable judges. Subsequently, a bench has referred Meghachandra to a larger bench saying that no, Parmar is good law. Those 3 judgments in a compilation I will hand over to your lordships, my lord, but that is the factual position of the Parmar. That larger bench is pending, but your lordships is in that larger combination, and that may not hold your lordship's hands in taking whatever view your lordship feels is the correct view. And especially, we will make it small. I will just put those 3-4 judgments together and then pass on to your lordships in a compilation.
What point?
Pardon me?
In Parmar,
Meghachandra said, you cannot get seniority from a date before which you are born in the cadre.
that's right.
Parmar said that date of occurrence of vacancy and initiation of process or issuing advertisement is the relevant date. It will relate back. Parmar is those income tax officers, my lord, case. So Meghachandran, relying on the subsequent judgments which said seniority can only be from the date you actually join the service, you cannot get earlier, said Parmar does not lay down good law. Then, but in a later combination, Justice Oak had actually referred it to a larger bench saying that no, Parmar does lay down law is correct and that reference needs to be relooked at. So that is where Parmar stands today.
Reference by decided by 3 judges.
Yes, references by two honorable judges, my lord. References by two honorable judges, and it is referred to a larger bench, which is still pending. We pass the following order. We are of the considered view that following questions need to be decided: whether the decision in the case of Megha Chandra can be said to be a binding precedent in the light of law laid down by the Constitution bench in Mervyn Contino and the law laid down by coordinate bench in Subhash Reddy. That this exactly what that Parmar is right. This is what has been referred. So it will come before 5. That will not hold your lordships back. While looking and considering and reconsidering, the only problem in this seniority on roster is if one process gets unduly delayed, then the problem comes. If it happens within the year, there is no problem at all. It is the best way forward, because then you are giving all 4 categories a representation in every block of 4, because roster is 2, 1, 2, 1, 2, 1, 2. It will go on. And in case vacancies are promotees are more, they will bunch below for that year. And next year, a fresh roster will be there. Fresh seniority will be maintained. But the only problem is if there are 2 years, 3 years delay, as in Delhi, and promotees come, that if your lordship will take care of that. And according to me, there can be because your lordship is focusing now on judicial services and removing imbalance in judicial services. So some framework, some scheme, some could be made by your lordships, my lord, in this combination, that the delay is minimized and does not in any case exceed 1 year, because that 1 year's buffer is there. Next year select list at the earliest will come into existence in September of the next year. So even if a process is delayed by 1 year and completed before September of the next year, still this can work. This system can work, and it will give a good result, my lord, if it works. Because so, my lord, this is my submission on quota, and this is actually my solution also, my lord, before your lordships. Now, roster. Now, my lord, so far as quota is concerned, the next point on quota, my lord, the point is that quota is really, the Lokinath says on source of recruitment, it's not possible. I mean, so therefore, my lord, if your lordship just wants to make a note on the side of it, the crucial 2 paras of the Lokinath are at page 789 of the judgment as it is presented before your lordships. It doesn't have paragraphs. It is page 49, at page 49 of volume 5A. Otherwise, my lord, in the SCC judgment, if your lordship would look at the SCC citation, the relevant paras are 45 and 46. But my lord, so far as Delhi is concerned, my clients whom I am representing, and therefore in quota we have put our second point. We are very happy with the amicus' suggestion. And therefore, my lord, while pointing out that this perhaps is not judicially possible, then what I've said is, alternatively, it is submitted that in the event this court comes to a considered decision that it is necessary and required for a quota to be provided, then, my lord, our submission is what the amicus is saying. 1:1, he is saying, we are quite happy with that.
Atwalya, what is your response to Jagannath?
To
Jagannath versus Union of India, 1992 supplement to SCC 105, paragraph 45 of the amicus brief.
para 45 of the amicus.
That is one case where Tirauke is considered, and the experience is taken as a parameter for classification.
Huh?
That's the only case where experience has been taken.
Page 45.
Paragraph 45.
Para 45. In Jagannath, my lord, yes, there also, my lord, in fact, it is, the facts are totally different. The facts of Jagannath are totally different. Huh? There, my lord, the facts were totally different, actually. Yes, it's at page 292, at 296. In fact, this is, my lord, of compositors working in government presses and the relief. My lord, these are totally different facts in which those observations are made. In fact, it's very crystal clear in more than one occasion, and this is on pay scale. If your lordship will see, it is obvious from the recommendations of the committee that highly skilled category was created to handle nature of work which involved higher skill. The compositors with longer service who were found fit for promotion were appointed to grade 1 and categorized at highly skilled. Since merit, there is a valid basis. This is, my lord, this is different. It is on some merit and skill.
The subclassification.
Correct.
And the parameter, the object and the subclassification on experience was held to be a good rational nexus.
But here the experience is the same for everybody, my lord, because here we are all part of the same cadre. Here you are doing the classification.
Your case here would be that the experience here is of the district judge entry level.
Correct.
And not the experience prior to.
Correct. And therefore, you are now going to classify them on the basis of their birthmark, their source of entry. That is held to be not valid at all. Yes. In fact, in 2002, the judgment also, this weightage has been, in the All India Judges case, para 30, which I have quoted, it has been categorically disapproved, which is subsequent to this judgment. Then, my lord, lastly, I have dealt with that one suggestion of the amicus that they should have 50% in the zone of consideration. You should include both 50% from the direct and 50% from the promotees. That will not solve any problem because the zone of consideration is always 4 or 5 times the total number of vacancies. Now, if the promotees are higher in the cadre and direct are below, or if direct are higher and promotee are below, and you pick up equal and put them in the zone of consideration, when you will make a common list, a senior person will remain on top of that list. The junior will remain. For example, in Delhi, in my case, promotees are occupying all the top posts and we are at the bottom. Even if 50% of us are taken in the zone of consideration, we will remain in the below 50% and the number of vacancies are much less. So people from the top will be taken and that will be completely a mirage. It will not solve anything. We will just go in the zone and come back from there. So, my lord, that is my submission to your lordships, my lord. I'm very grateful, my lord.
What should qualify in a case? Yearly recruitment is fine, ideally, that those 2 points of you can have a block of 4 and 2 to promotee, 1 to ALSE and the other goes to ITP. So that is on an ideal situation where, according to you, that if it happens within 1 year. Now, because of any unforeseen circumstance, if direct recruitment does not take place in a year, and it's not question of within next year also, if sometimes suppose it takes 4 years, 5 years, there is no recruitment. Or there is a single vacancy, the High Court takes a conscious decision that why should they undergo the entire selection process? After all, the selection process itself is a costly affair. So why should they undergo for 1 vacancy? So they wait for another vacancy to arrive. It may take 4 years, 5 years. And then the direct recruit claim those roster points. What is?
So for the second part of your lordship's observation, the answer is simple. Where the High Court decides not to put that vacancy in the public domain, there that vacancy then is not coming. It's on the year when the vacancy is put in the public domain that I will make my application. But yes, there is a problem in the first part of your lordship's observation that what happens when there is 4 or 5 years delay. Now, my solution to that is twofold. One, your lordships can put in place a mechanism that the delay doesn't go beyond 1 or 2 years. But if it does, then the only way that the submission can sustain is
then Rota is deemed to have broken down.
That is one answer. Then we go to length of service. For those facts, then, my lord, your lordship will leave it for the courts to cross those bridges when they actually come to them. Because today your lordship is laying down a general principle. In a general principle, I feel that your lordships could say in the same year or make some safeguard that it doesn't go beyond the next year. And then your lordship can mandate that where it is unduly delayed, the courts will examine the facts. My answer, hypothetically, academic answer will be, he should get it from the date it is actually put in the public domain. Not the second part, your lordship says, if there is 1 vacancy, High Court says, I am not going to circulate 1. We will do it next year. We will circulate 2 or 3 together. Nobody can have a claim to that one which is never circulated. To say, no, it actually arose in that year, therefore put me in that slot. My argument is not going that far. I'm only saying on the year in which it is circulated, and all 3 streams are circulated, because Malik Mazhar says, calculate the vacancies by February, 1st February, calculate also those which are likely to arise during the year, add also 5 or 15%, which is reduced to 5 later of anticipated, and then circulate.
This can very openly it can happen in the case of direct recruit. Reason is very obvious. First, you have only 25% quota. Then direct recruits are expected to join at a younger age.
Correct.
Therefore, their retirement, their resultant vacancy will arise only if they are elevated or they retire. or maybe.
Correct,
So
correct. But
therefore, the occurrence of vacancy within direct recruit 25% quota will be
far less.
far less,
Far-
will be quite slow.
Correct.
As compared to promote.
Correct, your lordship is right. And therefore, every judgment says those vacancies have to be calculated on cadre strength. So if promotees are retiring, the direct can't get a piece of that cake. That is all promotees vacancies. So, my lord, that is actually the submission before your lordships, my lord. And my actually point is that rota quota seems to be the best answer to this problem. I am very grateful. I'm grateful.
Thank you.
Lord.